All right. Good morning, everybody. Thank you for being on here. Any questions before I jump into what I'm going to talk about?
Not for me.
All right. Coolio. All right. Well, we will jump into it then. Before actually, just on that, in case you haven't seen on social media and things, those that went to go to Everest Base Camp. They made it to base camp, I think last night while we were all sleeping and stuff. But anyway, those that made it there anyway, which not all of them that went made it. I guess some of them had to got sick and air sickness and food poisoning and stuff. So not all of them made it. But anyway, all right. Here's what I was going to talk about today is we're going to go through and talk about the your affirmative duties that are required by you as a licensed agent. So I'm not going to spend a whole lot of time on any one individual thing, but just thought I would go through and talk about them. So, but as I do that, if you do have a question on one of them, want to talk a little bit more about it, I'm happy to do that as well. But just wanted to go through and give you a reminder about what your duties as a licensed real estate agent are. So, first one is to uphold the fiduciary duties. And so, like I said, we're not going to go into great detail on any of these right now, but loyalty, your obedience, full disclosure, confidentiality, reasonable care and diligence, and then the other one is just any other additional duties that are created by the agency agreement. So, if in an addendum to the buyer broker or the listing agreement, you were to put some additional things you were going to do, those would then become part of your fiduciary duties as well. So one is that we have to keep our fiduciary duties. Number two, we have to define the scope of the individual's agency by, and they've got a typo in here, but executing a written agency agreement between the individual and the individual's principal. So, and then it goes through to list who all that would entail. But just a reminder that you have to define the agency by executing a written agency agreement. And then number three, if you're representing both principals in a transaction as a limited agent, you have to obtain prior informed consent by getting that in writing from both parties and also letting them know that they could be represented by somebody else if they chose to, and then to go through and talk about the fiduciary duties that would then become neutral in those scenarios with your client to make sure that they are going to be okay with that. Number four is when you're acting as under a limited agency agreement, you have to act as that neutral third party that we talked about. So they specify that just a little bit more and making sure that you understand you've got to be neutral, which so for me, even had a transaction this week as the principal broker between two of our agents that we're working through. And I just have to keep reminding myself, like, I have to stay neutral on this. I'm not more on one side than the other, but it's fine to, relay messages and help out with things. But just reminder that you've got to stay neutral. You can't choose one side over the other. Number five, anytime you're making an offer or a solicitation to buy, sell, lease, or rent real property as a principal, either directly or indirectly, or as an agent for the client, you have to disclose in the initial contact with the other party the fact that the licensee holds a license with the division and whether it's active or inactive. So anytime you're coming in contact with somebody, basically, is you need to disclose to them that you are a licensed active real estate agent and in making any of those solicitations that you would either for yourself or on behalf of a client. Okay. Number six, before the execution of a binding purchase or lease agreement, disclose in writing to the client's agents for other parties or unrepresented parties that you are a principal in the the licensee's position as the principal in any transaction where you're acting either directly or indirectly to buy, sell, or lease or rent properties. Okay. Number 7, before offering any property for sale or lease, make reasonable efforts to verify the accuracy and content of the information and data to be used in the marketing of the property. So on this one, again, it's just making sure that you are putting in a reasonable effort, whatever reasonable effort actually means, to verify the accuracy of the information. So basically, I would say reasonable effort means you got to be able to show you did something to verify the accuracy of that. And again, this is a good point to pause for a second and just bring up that in the event that you have an issue, the attorney on the other side of a lawsuit, if that were to happen, is going to use these things out of what the division has put in here to say, in this case, of did you make a reasonable effort to verify the accuracy of that, and what did you do? So I guess I would just say make sure you've done something, which would then be classified as reasonable, so that you can show that you did make a reasonable effort to verify the accuracy. So such as square footage, things like that. Okay. All right, number 8, before offering a residential property for sale, disclose the source on which the licensee relies for any square footage data. So on this one, we've got that both in the seller disclosures, but then also you've got to disclose that. Now I'm going blank on the other one. In the listing agreement, sorry, that you have to put down where you got the square footage from, which that one's always a little ironic because sometimes we got it from the seller. So we have to disclose to our seller that we got the square footage from them from an appraisal or whatever it is that they gave to us. So anyway, always making sure that we're disclosing where we got the square footage from. Number 9 is upon initial contact with another agent in a transaction, disclose the agency relationship between the licensee and the client. So anytime you're coming in contact with another agent, letting them know that you represent the seller or whoever it is, if it's a buyer, the other way around. So making sure you're doing that. Next couple of these aren't as applicable. Well, no, this one still is. It's after that. So number 10, when executing a binding agreement in a sales transaction, confirm the prior agency. So that would be making sure that in section 5 of the real estate purchase contract that you have put in there that that's a confirmation of that prior agency. So the other thing that I would point out on this is I saw a contract this week, and they did have this in there, but anytime you are executing a binding agreement, so if you've gotten, and the one I saw this week was an agent that had received an offer in from somebody that was not written on a real estate purchase contract, which again, it's okay to use those, such as a builder's contract and stuff, as long as it was written by an attorney. So those have to be written by an attorney. But just because we have this other transaction, remember that anytime you're executing that binding agreement, that you've got to confirm in there. So if you do get one, so like they say, for instance, this week, the agent had one that some buyer had an attorney put together, but it did have a section in there that was the confirmation of agency. So just a reminder that that is one of your duties, is to ensure that anytime you're doing a binding transaction, that there is that confirmation of prior agency in the contract. So like I say, the Repsi's got it built in. Typically, you're going to have that built into builders contracts, but just anytime you see one, just ensure that it does have that built into the contract. Number 11 is when executing a lease or a rental agreement, confirm the prior agency. So similar to what we said for number 10, but this would be on leases. Number 12, if the licensee desires to act as a sub-agent for showing property owned by a seller who's under contract with another brokerage, then this would list out the things that you would have to do. Really, though, I would just say on this one, make sure if you were going to try to do something like that, that you get me involved in it. The challenge that we always have of acting as a sub agent for another agent that has a listing with somebody else. So this would really kind of be a scenario of you showing the property for another agent that has the property listed. But the challenge that we always have in those is going to be liability. If something happens, the listing brokerage has in their agreements they're not responsible. But if you're out doing it and you don't have any type of an agreement with them, you could potentially be taking on some liability. So anyway, like I say, if they were going to do something like that, get me involved in it just so that one, we see if it really is something we should do, but then two, if we do, that we make sure we get protections put in there to protect you and the brokerage as well. So
So, Russ,
num-
can I ask a question about that really quick?
you bet.
So, if we have like a showing agent, like someone that's going to show our buyer's property, but they don't have an agency agreement written with them, it's written with me. Is that when we do that?
Well, so would that agent be someone in our brokerage?
Yeah.
Yeah, then you're fine. You don't have to worry about it
Okay.
because they would be anybody within the brokerage. So what that one is talking about is acting as a sub agent for somebody who's under contract with another brokerage. As long as they're with our brokerage, it's not a problem.
Okay. Thank you.
Yep. Number 13 is provide copies of a lease or a purchase agreement properly signed by each party to the party for whom the licensee acts as an agent. So on this one again is just a reminder, we have a responsibility once they have signed to give them copies of everything that they have signed. So make sure you're giving your clients copies of the contracts after they've signed it. And it should be like reasonably quick, meaning like if you're doing it in person, hopefully have an extra copy to give to them there or make a copy at the office. If not, as soon as you get back to the office, get them a copy there as well. Number 14 is in identifying the seller's brokerage in paragraph 5 of the real estate purchase contract. You can either use my name or the brokerage name is what this is saying, is either one is going to be fine to use. The recommendation is just to use the brokerage's name, and I think that's what most everybody's doing. But just reminder that you could use my name if you wanted, but recommended to use the brokerage's name. Number 15, timely inform the licensee's principal broker, or a branch broker of a real estate transaction in which you are going to be involved as the agent or the principal. So the idea of this one is just making sure that the brokerage is aware of what you're doing. We have had scenarios where we've had closings come in and we have no record of any type of a transaction before the closing shows up. And so if somebody were to make a complaint about that, which I probably won't do, but could be me even, I guess. But if somebody were to file a complaint about a transaction and the division found out that you had not informed the brokerage about it, that could be an issue against your affirmative duties. So just making sure that you're letting us know once you get an offer written and accepted and things, getting it into Loop and submitting for review. I know Julie and Brianna appreciate that very much when they're not having to get a closing and go then track down like, why do we not have any paperwork? But it happens. So make sure you're doing that. 16, disclose in writing to each party to a transaction any compensation in addition to any real estate commissions that will be received. So if you're getting paid some type of a referral fee for a referring some other service or something, you have to disclose that. So any compensation in addition to your real estate commission, you've got to make sure you disclose that to your clients that you are getting paid for that referral for, a home warranty or whatever if it was. So number 17, in negotiating and closing a transaction, you can fill out legal forms provided by an attorney. So basically, we are allowed as agents to somewhat act as an attorney because of this provision here. but basically what that's saying is we can fill out the forms. So we can't go create our own forms and that kind of stuff, which leads to number 18, which number 18 is use an approved addendum form to make a counteroffer or any other modification of the contract. So this one is saying if there's an addendum that exists already, you need to use it. And I even yesterday saw a counteroffer that somebody had done, which I was like, oh, there's actually, and it wasn't from our agent, it was coming from another agent. So we're fine because we didn't generate it. But basically use the approved form if it's there. And the idea of that is, sometimes agents will counter and say, subject to the sale of the buyer's home. Well, we've got an addendum for that. And the idea of why the division is saying this is there are protections built into those forms that you just doing a counter and saying subject to the sale of the buyer's home is not giving your client that extra protection that the form would give. So if there is an addendum that exists, make sure that you are using it. If there's not, you can fill out the blank addendums. It's just be careful that you're not making those so complex. And again, if you're going to do something like that, get me involved in it just so that we can make sure that you're protected, that you're not, somebody doesn't come back on you for basically acting as an attorney. Okay. Uh, Number 19, before signing or initialing a document on behalf of a principal in a sales transaction is saying to get a power of attorney. I am saying don't act as a power of attorney for your client. So this section is saying if you're going to sign something for your client, you've got to have a power of attorney. I'm saying don't do it. That is our company policy would be don't act as a power of attorney for a client because it's just putting too much risk on you and the brokerage. Find somebody else that could do it. A neighbor, a friend, whoever, but don't you do it. But then this does go through and explain again how to do that, which we've talked about before, but is it anytime somebody is acting as a power of attorney, so not you, but whoever, they're going to put the principal's name by the licensee's name, comma, attorney in fact. And then on the initials, this one's the one to make sure that this one's the one I think people aren't as familiar with. But so it should be the principal's name, the principal's initials by the licensee's name, not your initials, but so the principal's initials by your name, attorney in fact for, and then you're going to put the principal's name. So it's kind of crazy that on the initials becomes this even longer thing that you've got to put on there to make sure that it's done properly. So, all right. And then let's keep going down here. Number 20, before signing or initialing a document on behalf of a principal in a property management transaction, and then it lists the same thing, you're going to sign it, the licensee's name on behalf of the owner, and on initials, same thing, licensee's initials on behalf of the owner. Okay. 20, but again, back to being a power of attorney. Really want to emphasize, just don't do it. Get somebody else to do it. Number 21, if employing any unlicensed individual to provide assistance in connection with a real estate transaction, adhere to this section here, which we'll do that on another compliance call where we'll go through and talk about when you've got an unlicensed individual acting as an assistant, how to handle that. But number 22, strictly adhere to the advertising restrictions outlined in this section, which again, we'll do that as another compliance call. And then as to the guaranteed sales agreement, provide full disclosure regarding the guarantee. So when you hear people talking about, we will guarantee that we get your home sold and stuff, there are things that you need to do in addition to that. So again, if you're going to do that, let's get together and talk about it to make sure you have all the protections in there for yourself. And then two more of these. Number 24 is immediately deliver money received in a real estate transaction to the principal broker for deposit. So again, the transaction is giving you some additional time, but the division is saying really you should just deliver it immediately after you've received it. So really the best idea is once you receive earnest money, make sure that it is given to the brokerage so that we can get it deposited right away. And then number 25 is saying, as contemplated by subsection this, but here's the point of it is when you are notified by the division that information or documents are required for an investigation. So typically that's going to happen is if somebody files a complaint against you, you have to respond and give them all of that information within 10 business days of you getting that complaint or that request from the division asking for you to give all that information back. So anyway, just a good reminder about your affirmative duties. So the things that you have to do. Again, we'll do another one another time about your prohibited conduct that is prohibited from you guys. But anyway, any questions, thoughts,
Should we have a
comments?
copy of this, or is that not important?
I don't know that I mean, you totally fine if you did have one. I'm probably not a bad idea. I don't think it's required that you have one. More so, they just want to make sure that you know, and thus us doing this just to remind you of what the duties are. But probably wouldn't hurt to have a copy, but not required. Any other thoughts or questions? I know not as exciting today, but also still good just to go through and talk about, hey, reminder about what your duties are. Because in the event somebody files a complaint against you at the division, those are the things they're going to use, those and the prohibited, to say you either didn't do what you were supposed to do or you did something you weren't supposed to. So anyway,
Hey, Russ, I just wanted to
yes.
ask quickly. Um, and I know
Thank
we've
you for
gone over
turning your
this,
camera on.
but I just wanted to ask. So on, not on, it wasn't on this stuff, but it's once in a while so I've been just doing some AI stuff that posts stuff on social media, and it'll like post a house. It's a listing of someone else's, right? It's like price drop. That's okay, right? I mean, it's doing it. I wanted to remind myself of what the guidelines are.
Yep, no, you're good. So good to ask the question. So anytime you're going to advertise another agent's listing or a brokerage's listing, you have to have permission from the seller and the brokerage. So really basically just get permission from the brokerage and the broker and you'll be good. So get something in writing from them saying you can advertise it.
Well, that's why I was wondering. Like, it's weird. Like, so this is in the software, right? Like, so Lofty will go and it'll post these auto stuff of just like listings. Like, is that so we can't do that?
You really can't without permission from
Okay.
the seller and the broker to be able to advertise. So yeah,
Okay.
unfortunately.
Russ, I thought
Interesting.
that if it was posted on the MLS, it's that, because that MLS listing, they've already agreed to advertising. So
So
do that?
if it's an IDX feed, like so if you're advertising it on a website, that type of stuff, yes, but going out and doing like even just going and knocking on doors or something,
Oh, yeah.
it's best to have permission. So yeah, if it's
So
an
this is
IDX
just
feed,
comes from the IDX. I mean, it's all
oh
just
yeah,
uploading from the MLS stuff.
okay,
It just kind of says,
yeah,
"Oh, look at this beautiful home," because it'll
then you should
basically
be good.
trigger off someone's stuff. Okay. I figured as much. I'm like, I don't know why
Yeah,
Lofty would do that if
yeah,
we aren't allowed to do it at some
yeah.
point,
No,
but
with the IDX feed, any of that type of stuff, you're fine. Yep,
okay. All right. Thank you.
you're welcome.
Thanks, Russ.
Yep.
Thank
Anything
you.
else?
Have a good
Okay. Well,
day.
hey, thanks for being on, guys. And Keith, thanks for turning your camera on. I'm gonna
Yeah,
start
you're welcome.
giving out a reward for people who put their camera on. Oh, now Ruby did.
Oh,
See, there we
yeah,
go.
there you go, Ruby.
It's awesome. Well, I
All right.
appreciate it. It's always nice to be
Yep.
able to see somebody else's face besides my own on here. So
Actually, you're right. Yeah.
anyway,
You're
okay.
welcome.
Thanks, guys.
Okay.
All
Have an
right. See
awesome
ya.
weekend.
Bye.
No, we
Bye.
will not do a compliance call next week with Thanksgiving and the office being closed, just as an FYI. But
All right.
thanks for being here.
Thank you.
Okay. See ya.
You.
Bye.